Excellent. Hello, and welcome to our property update webinar. Thank you very much for taking the time to join us today, and I hope you're all well in these continuingly difficult times. I'm Chris Longden. I'm the Managing Director of Whitehead Moncton. Today's webinar is all about residential and commercial landlord and tenant issues. As you'll doubtless be aware, over the last 9 months or so, the government's brought in a raft of measures, mainly to protect tenants in respect of their tenancies of properties. And the measures have evolved and been extended, changed somewhat over this period of the pandemic. Hopefully, what we have to say to you today will be of interest to all of you to some extent. Our first speaker today will be Sam Mulligan. Sam is a solicitor in our dispute resolution team and specialises in all things landlord and tenant, particularly on the residential side. So Sam will be talking to us about residential updates, which is quite a complex area. When Sam's finished, our next speaker will be David Riordan. David's one of our associate directors at Whitehead Moncton and heads our dispute resolution team. And David will be talking to us about the commercial update. Welcome all and any questions you may have. And the way we'll deal with questions is, I think we'll allow both speakers to speak first, and then we'll deal with questions at the end. Send in your questions during the course of the talks, and then we shall pick those up. And please don't be shy. And of course, if there are any questions which you don't get round to asking or we don't get round to answering, please do make sure you email us afterwards and we will endeavour to get back to you. So without further ado, I'd like to pass over to Sam to talk to us about residential tenancies. Sam.
Thanks, Chris. Yeah, as Chris was saying, there's been quite significant changes on the residential possession side. So I'm going to talk through a number of those changes today. And really, given that there were quite a few changes over the summer period, trying to sort of take stock of where we are now and reflect on what we are doing at the moment. So I put on the slide there a number of points which I would like to touch upon today. The first is the grounds for possession and the revised notice periods. With a particular focus, obviously, on short hold tenancies, which are going to be most of interest to private landlords and their agents. Then I want to move on to look at the new procedures that apply for residential possession claims, and then looking at the rules relating to prioritisation of cases and generally sort of looking at how long you can expect to wait for your claim to be listed for a hearing. And then finally, just touching there on the current state of evictions. So firstly, looking at the grounds for possession, as I say, concentrating on short hold tenancies. The main grounds that landlords are going to be aware of already is Section 21 of the Housing Act. So this is the no-fault ground where landlords previously would have gone to this as the go-to ground because it would have only required 2 months' notice to be served, and provided you've made out the requirements, you could then be confident that you were going to be able to recover possession. Unfortunately, that has changed a bit. So over the summer, the notice period was extended to 3 months. It now stands at 6 months' notice has to be served in all cases. Then there's a number of other requirements there that I put on the slide. So the notice cannot be served within the first 4 months of the tenancy. Possession proceedings have to be brought within 10 months from the date of service of the Section 21 notice. And then obviously there's a number of other procedural requirements that still apply. So for instance, you have to have your gas safety certificates, EPC certificates, how to rent guide, that sort of thing all has to be served prior to serving Section 21 notice. So it is worth making sure that if you're serving a Section 21 notice, with that increased 6-month notice period, that you're doing things correctly. Obviously, you don't want to get to a stage where you find out there's been an error after waiting for that 6-month notice period to expire, having put in the claim with the court, only for the claim to then be dismissed. So it's important that you're getting that notice right at the outset. And one thing I would say there is make sure that you are serving the correct form of notice. And by that, I mean there is an updated prescribed form of Section 21 notice available on the .gov website. So always make sure when you're serving a Section 21 notice that you are using the latest Section 21 prescribed form, because I frequently see that there is notice being served and it's on the wrong form, and obviously you don't want to end up in a situation where you've served 6 months notice and then you find out after that that you've made a mistake. The other ground that private landlords rely on is obviously Section 8 of the Housing Act, and the particular grounds are grounds 8, 10 and 11 that we frequently see used, which are the rent arrears grounds. Ground 8, as you'll probably be aware, is the mandatory rent arrears ground, which means the judge doesn't have discretion. Grounds 10 and 11 are the discretionary grounds, but they're all rent arrears grounds. So again, there's a 6-month notice period that applies. That can be reduced down to 4 weeks notice, where the rent arrears rent arrears at any time are not less than 6 months. So it can actually work out that it's better to delay serving the Section 8 notice, and then you can rely on the 4 weeks notice. As to the other grounds that can be relied upon, I've put a link there on the slide. The notice periods have changed, but there isn't time to go through each of those today. But what I would say is look at the prescribed form of Section 8 notice, and the timescales are all set out on that notice itself. Moving on then to consider some of the procedural changes that have been introduced. Now, these have been introduced by a range of means. So I've put down on the slide there some of the ways that this has been introduced. There's the new Practice Direction 55C, which applies until at least the 28th of March 2021. And then there's a number of other documents that also provide further clarification around what the procedure will be. Firstly, looking at existing claims. If you've got any existing claims that were subject to the stay, so the stay applied between the 31st of March 2020 and the 20th of September 2020. So if you've got any claims that are subject to the stay and they were issued before the 3rd of August 2020, then you do actually have to serve a reactivation notice in order for those claims to be restarted. Now, I'd hope that most of you will have already served those reactivation notices, but if you haven't, then there is a deadline of 4 p.m. on the 29th of January by which those reactivation notices have to be served. And there's particular requirements to go into the reactivation notice. So you have to say what knowledge you have as to the effect of the coronavirus pandemic on the defendant and their dependents. You have to include an updated rent account for the previous 2 years if you're relying on a rent arrears ground. And whilst it's not a prescribed form, there is a template notice available on the .gov website, which will no doubt come in handy. And there's also some additional requirements if you've got a case which has already had directions issued. So it's worth bearing that in mind as well, that there are some additional procedural requirements that will apply in that situation. As for new claims, so this is where it perhaps gets a bit more interesting. So if you've got a new claim that's just about to start, previously it would have been the case that when you sent the claim form and the particulars of claim to the court, you would have received your notice of issue, and at that point you would have expected to receive your notice of hearing, and that would have typically been an 8-week period between issue of the claim and the actual possession hearing itself. So that has changed. When you send the claim form to the court for issue, you'll receive your notice of issue, but you won't receive the hearing date there and then. And furthermore, the 8-week period between the notice of issue and the hearing no longer applies. There is an additional requirement, so when you're sending in a new claim and you're relying on the accelerated possession procedure, so this is where you're seeking to rely on section 21, you have to, with the claim form, you have to fill out a notice setting out what knowledge you have as to the effect of the coronavirus pandemic on the defendant and their dependents. Then generally in respect of new and existing claims that are brought after the 3rd of August 2020, you have to bring along 2 copies of that coronavirus notice, which I've just referred to, so that would apply in all cases that are brought after the 3rd of August 2020. And you also have to serve that notice on the defendant not less than 14 days prior to the hearing itself. There is also generally a 2-stage procedure that will apply. So whereas previously, as I've said, there would have been, the notice of issue would have been sent, and with that you would have received your notice of hearing at the same time. Now there's a 2-stage procedure, so there'll be a notice of review, so you'll receive a review date. 21 days notice will be given of that review date, and then 14 days before the review date you have to file certain documents with the court, and they include an electronic bundle of all of the documents that have been issued by the court, and you have to also confirm to the court that a paper bundle has been provided to the defendant, and the bundle includes all required enhanced material, which includes those coronavirus notices that I've already referred to. And then you also have to confirm that the claimant will be available during the review date to discuss the case by telephone. Then on the review date itself, you have to actually be available in order to be able to discuss the case with the defendant or their advisor. That would usually be by telephone. And then at the end of the review date, the court will review the case and determine whether or not further directions are required, or if there has been a settlement of the case, it might approve a consent order that has been agreed. Then 28 days after the review date, there will be a substantive hearing. I say 28 days afterwards, it's perhaps more likely to be more than 28 days in the current climate, but it'll be at least 28 days after the review date. All parties are expected to attend, including witnesses, and the hearing itself will be listed for 15 minutes. The parties can request a remote hearing, but the judge has discretion as to how that proceeding, as to how that hearing will be proceeding. As I've said, in practice, there are delays in the system at the moment. It's not sort of unheard of for there to be sort of several months delays between issue of the claim and actually the notice of review. And none of my cases yet have actually made it to a substantive hearing, those that were subject to the stay. So in terms of prioritisation of cases, what's important at the moment is that if you have got any cases that are ongoing, that you do try and rely on the categories of cases which are supposed to be prioritised. And I've listed some of the key ones on the slide here, and it's probably worth drawing to the attention of the court that you think that your case should fall within one of these priority categories. And the key one that I've highlighted there on the slide is extreme alleged rent arrears accrued. And this is where the arrears are equal to at least 12 months rent or 9 months rent, where that amounts to more than 25% of a private landlord's total annual income from any source. So that's an important sort of priority case, which will apply in a number of cases and which is worth drawing to the attention of the court. Finally, I just wanted to touch upon the stay on evictions, which currently is in place. This was otherwise known as the winter truce, and it applies until the 11th of January 2021. However, in practice, it will be until at least the 25th of January, on the basis that at least 14 days notice are required. So there are some exceptions to the stay, and I've put a couple of those on the slide there. In practice, in order to be able to rely on an exception, you would have to actually make an application to the court. So that's not something that's going to be all that easy to do. But there might be situations where if you've got a possession hearing coming up now, and you're expecting a possession order to be made, then it's worth asking the court at that stage to note which exceptions apply, and that will actually then be recorded in the possession order itself. And there is a rent arrears exception that can apply for substantial rent arrears, and in this case, substantial arrears is arrears of at least 9 months arrears at the date of which the possession order was made, although it can't include rent arrears accrued after the 23rd of March 2020. So I think that's everything that I wanted to touch upon. Obviously, if you've got any questions, do send them through and I'll try and answer them at the end of the webinar. But I'm going to pass it back now to Chris. Thank you.
Thank you very much, Sam. And I found that very enlightening myself, and I hope it was of interest. As Sam's just said, we'll certainly have time for questions at the end, so please do send in your questions. One point which has already arisen is, I think, a request for the slides from this presentation. I can confirm those will be available, and we will email those out to the participants after we have finished. Thank you, and David, over to you.
Thank you, Chris. I'll just bring up my slides. Hopefully everyone can see my slides now. So as Chris mentioned, I'm going to talk through commercial leases and provide an update in respect of coronavirus and the impact upon landlords and tenants. I'm going to talk about 4 different things today. Those include contract and force majeure clauses, rent, recovery and statutory demands, and also finally forfeiture and recovery of possession. Now being that I want to try to give you the legal parameters as to where we are in terms of coronavirus when you're taking those difficult practical and ethical decisions in respect of your property and your commercial tenancy. So running through those, the frustration of contract and force majeure. Well, what is it? The doctrine of frustration allows for contracts to be brought to an end in certain circumstances. Those would include where there's a frustrating event must occur after the contract was formed, event no fault of either party to the contract, or which was not in the contemplation of the parties and have made the performance of the contract impossible, illegal, or radically different. Now, in practice, in terms of leases, those will normally be encapsulated within a force majeure clause. And it's worth checking your lease to see if it's a force majeure clause, specific wording, as that will be key in whether it's going to come into force. The sort of wording that you might be looking for is whether it refers to circumstances it's likely that the force majeure clause during coronavirus, or alternatively, if it makes reference to an act of government, then looking at more fine points in terms of whether you've been legally from trading. There's simply been guidance at a certain time. But either of those circumstances could give rise to a force majeure being effective. It's also worth considering procedure would be in order to make the force majeure clause effective, that you would have to give notice, and of course therefore you also need to check service provisions to ensure that those have been complied with. isn't a force majeure clause, then you may have to seek to rely upon the doctrine of frustration of contract. And broadly, it's likely that that's going to be more difficult to do, as the pandemic will be temporary. If tenants seek to argue frustration of contract in relation to the second lockdown alone, then face battles as to what was foreseeable. Because, of course, whilst the initial lockdown was wholly unforeseeable, the second lockdown arguably was more foreseeable. In summary, force majeure clause arguments may be more fruitful than relying upon the doctrine of frustration, but it will depend upon the specific wording of your clause. Moving on and looking at rent reduction. So the standard position is that the rent remains payable under a lease. Certain instances whereby the lease could contain a provision which would suspend the rent, but that would normally be in circumstances such as where there's been damage of the premises. This has a turnover rent and is based on a turnover rent, then of course that may have had a significant impact on the landlord, particularly if the premises is a retail premises. Landlords have agreed rent reductions with tenants, and happened, then the key, of course, is to ensure that it's well documented. Likewise, certain landlords have suspended rent, with the quarterly or monthly payments to be repaid over future quarters or monthly payments, stage payments. In terms of the obligations on landlords, if they have an obligation to provide services under the service charge provision, those will remain effective. Again, worth looking at the specific wording of the lease, because it may be that in some way the landlord's given some leeway if the wording provides for it. The landlord has to use their reasonable endeavours in order to provide the service charge. That may allow some leeway to argue that the circumstances are such that it's not been possible. In terms of whether landlords are obliged to provide clean, again, look at the specific wording of the provision, because if it provides for keeping the premises safe, then it's going to be more arguable that there is scope to undertake a full deep clean. In terms of whether those costs are chargeable to the tenant, again, it's looking at the specific wording of the lease and as to whether the lease entitles the landlord to do so. Issues may arise in terms of closure of the building, and obviously there's been points at which in businesses, the government has businesses to close. And worth checking as to points at which there's been an obligation to close or where there's been recommendations, because that may have an impact upon whether the tenant is required to continue paying rent at that time. In circumstances where the freeholder has closed a building so that the tenant could not trade, then the tenant may be able to seek to claim their losses for not being able to trade in that period. So careful attention needs to be paid as to spaces upon which the premises could not be used. Any leases will contain a keep open clause, and there's no case law at the moment as to whether the courts will engage tenants to those keep open clauses. Widely thought that a court would not come down heavily upon a tenant who's failed to adhere to the keep open clause given the current circumstances. We'll have to see if any such cases do come through to the courts in due course. And finally on that, worth considering your insurance and business interruption. It could be the scope to bring a claim on such a policy. In terms of rent recovery and statutory demands, well, Schedule 10 of the Corporate Insolvency and Governance Act provided that the 27th of April 2020, and which has subsequently been extended to 31 December 2020, a creditor cannot present a winding up petition unless there are very circumstances in place. If it's reasonable grounds to believe that either coronavirus has not had a financial effect on the debtor company, or that the company was unable to pay its debts regardless of the financial effects of coronavirus. Now, in instances, that will prevent any winding up petition being presented against a tenant. A case, Tundra Limited, which was decided on the 8th of July, whereby that test was actually met and that a winding up order was granted against the company. It did have quite specific circumstances, and in that case, and to have a balance sheet, or sorry, to have been balance sheet insolvent going back to 2018. And the petitioner could only succeed if the would have arisen, even if coronavirus had not had a financial effect on the company. In that case, Judge Mullen found that as it had been over a year, not been made, he accepted that the last filed accounts showed that it was balance sheet insolvent and did grant an order. Important to recognise, though, that no winding up petition could be brought at present in respect of a statutory demand served March and continuing again until the 31st of December. The forfeiture of a lease and recovery of possession. Well, once again, there's significant restrictions in place. Coronavirus Act 2020, sections 82 and 83, provide that there's a 3-month moratorium, which has since been extended to the 31st of December 2020, on forfeiture for unpaid rent. So landlords are unable at present to seek to forfeit for unpaid rent. In any existing proceedings, there'll be no possession order granted until the same date. It is still possible to forfeit for by peaceful re-entry for non-rent breaches. Now, I would say that we would very rarely advise a client to seek to forfeit by peaceful re-entry in those circumstances. So, whether it provides much of a way forward for landlords, I'm not so sure. Forfeiture and recovery of possession, rent will remain payable and the lease continues to operate in the normal manner. In terms of CRAR, which is the statutory scheme for commercial landlords to recover rent, control of the tenant's goods at their premises and then selling them, there's further restrictions in place. So from the 29th of September 2020, there must have been 276 days of unpaid rent. Landlord would be able to employ CRAR. Extended from the 25th of December 2020, 66 days. So there'll have to be an even greater amount of outstanding rent at that point in order to seek to utilise that statutory scheme. Of course, as with all of these, and as happened today throughout the pandemic, scope that they will be extended further again, and that we will find coming into the new year that there's an additional extended period in which there's further restrictions put in place. Looking broadly overall, you can still bring a money claim at court, but of course, with that judgment, you won't be at the moment able to serve a winding up petition or statutory demand based upon it, and you won't be able to CRAR at the premises. In terms of practicalities, therefore, landlords, look at your premises and the market and look at the reletting potential, the issue of tenant insolvency, because those are all factors that need to be taken into account when considering whether to look at negotiating and agreeing a payment plan or to take a harder line in terms of breach. I hope that's been of some assistance to you all, and it's taken you through some of the legal areas that we've been looking at overall for commercial properties and commercial landlords. We are happy to take any questions that you have now, so please do fire away with those. I'll just release my screen.
Thank you very much indeed. And I'm also pleased to say that we have had some questions. So let's move straight into them. I think this is probably more directed at Sam. But I shall read it out. As a landlord insurance broker, we used to provide a rent guarantee product, which came into force when an eviction notice was served for rent arrears. An eviction ban, this was withdrawn by providers to avoid mis-selling. Being asked regularly about the future of this product and have no answers. In your eyes, will the eviction process go back to normal in the future, pandemic allowing?
Yeah, that's an interesting question in terms of what will the future hold for certainly on the residential side. As we said, there have been a number of changes over the summer months. Now, in terms of the current notice periods, they will apply, I think, until the end of March. It's the 31st of March 2021 when the notice periods will come to an end. And as I said on the slides, which will be circulated after the webinar, there is this Practice Direction 55C, which is in place until a similar period of time, so at least the 28th of March. So for the time being, certainly the procedures aren't going to be changing in the short term. And I suppose at March, we don't know what the procedures will be after that date, but it's quite possible that things like the extended notice periods, it would seem to me that it's quite possible that they could remain in one form or another. But we really don't know at the moment quite what the future will hold.
Thank you, Sam. We have another one for Sam. Right, here goes. So what is the position if a Section 8 notice was served back in February, so it'd be February 2020, proceedings had not been commenced? Can the old Section 8 notice still be relied on, or does a new Section 8 notice need to be served?
Yeah, so if it's Section 8, the process is a bit different. So if it's Section 21, as I said on the slides, the notice is valid now for 10 months from service. So you have to issue the proceedings within those 10 months. Whereas for Section 8, which I think is what you were saying there, Chris, if it's a Section 8 notice that was served back at the start of last year, then that will remain valid, provided it was obviously valid as served, because Section 8 notices are valid for a period of 12 months. So yes, you can still rely on the old Section 8 notice that was served back in February, and that shouldn't present an issue provided it was valid at that stage.
Further question for Sam. Maybe we should try and deal with the residential questions before coming on to David. Talked previously about Section 21 notices being abolished. Where do we stand on that at the moment? Yeah,
so this is similar to the first question in many ways, in the sense that we don't know quite what the future holds. Obviously, there was talk of abolition of Section 21. I think it was mentioned back in April 2019 for the first time. And then since then, it has been repeated on a number of occasions. I think there is a renters reform bill currently sort of drafted and ready to go, but as to whether that will actually ever make it onto the statute books, I anticipate the government has bigger priorities right now in terms of other sort of coronavirus related legislation, but certainly as far as I've heard, it hasn't sort of gone off of the agenda, and one would therefore assume that it will be picked up again at some future date. So yes, definitely one to look out for and to be aware of. The one thing I would say on that is Section 21 is obviously heavily relied on at the moment, so it's important to look at what alternatives might be able to be relied upon if Section 21 isn't available. And by that I mean, for instance, Ground 1 is something that I've looked at recently, which is where an individual wants to reoccupy the property for their own sort of purposes. So it might be worth making sure that any notices for relying on things like Ground 1 have been served at the outset of the tenancy, because that's going to become more and more important in the future than what it perhaps currently is. So just a word of caution there.
Thank you very much, Sam. We have I think, well, presently a final question for Sam before perhaps we move on today, because there are a couple of questions on the commercial side too. So final question for Sam. We have a tenancy where we have not protected the tenancy deposit in one of the protection schemes. We've been told we cannot now terminate the tenancy. Is that correct?
So if the tenancy deposit hasn't been protected in a scheme, and you're trying to rely on Section 21 being the no fault ground, then that is potentially correct as it stands, albeit there are routes around that. So if you haven't protected the deposit within the 30-day period like you should have done, then you do have a few options available. Unfortunately, none of them are going to be particularly palatable, but they are options nevertheless, which will allow you to serve the Section 21 notice. And they are, I guess, you could return the deposit to the tenant, which will then mean that you're no longer non-compliant for the purposes of Section 21 at least, albeit there is still a financial penalty that can be imposed, but that requires the tenant to actually make a claim. So, and that financial penalty is between 1 and 3 times the deposit amount. So it's worth bearing that in mind, but quite often the way to get around this is just to return the deposit and hope that the tenant doesn't raise the issue of non-compliance, albeit they obviously can. The alternative is to serve a Section 8 notice. As I said during this, when I was speaking over the slides, Section 8 can be served on a number of grounds, and grounds 8, 10 and 11 tend to be the most frequently used ones for rent arrears. But there are other grounds that can also be relied on in certain cases, for instance, antisocial behaviour and that sort of thing. So it's worth looking at those grounds to see whether any of those might apply to the individual circumstances of the case.
Thank you very much, Sam. Let's move on to David, because we do have a couple of questions. So David, if you bring a money claim against a guarantor to a lease and obtain judgment, can that be enforced?
Well, I mean, it can be enforced in respect of options such as having bailiffs attend a property, so i.e. related to CRAR or unrelated to any steps, for example, in respect of forfeiture. So there are some enforcement options, but you can't go through any forfeiture procedures at the moment, and you can't go through CRAR. You could, if you had a money judgment, if the other party had a property, you could still seek to place a charge against that property, or look at other options, including attachment of earnings order, etc.
Thank you very much, David. Next one, second one for David. My commercial premises are empty and I'm concerned trespassers may move in. Can I evict trespassers?
Yes, you can still bring proceedings against trespassers. It's only commercial tenants who you're unable to seek to forfeit against at the moment.
Thank you very much. And presently a final one for David. I'm a commercial tenant, a tenant rather than landlord here, commercial tenant, and do not believe that I have a force majeure clause. Can I surrender my lease?
Well, I mean, you're not entitled to surrender unless your landlord agrees to accept the surrender. You can seek to negotiate with your landlord and see if they would be willing to accept. And of course, they may do so if they consider that there's some scope for them to or to find a new tenant who they feel may be able to pay the rent. But it would be a matter of negotiation as opposed to something you're entitled to do.
Thank you, David. Other questions just at the moment. We've been through several there, which is very good. I always like to see some questions and some engagement. One thing I would just mention is that we are expecting imminently some further announcements with various changes due to expire at the end of the month. And if those announcements are made regarding in particular moratoriums on forfeiture and that sort of thing, we'll obviously let you know. Otherwise, we'll send out the slides following our conclusion. Don't have any further questions at the moment. Any concluding thoughts at all? Sam, do you have any concluding thoughts that you'd like to share with us in terms of how you see things?
Sorry, my mic was muted there for a minute, but I think the one thing I would say is obviously we've seen a period of uncertainty over the summer. I think things have quietened down a little bit now in terms of where we are. We know what the procedures are, but I think I can see that there is going to be a period now where the courts are going to be very much sort of inundated with possession claims. As you've just alluded to, the moratoriums on commercial cases are due to be lifted shortly, and that's going to mean there's going to be even more cases in the system. So it's going to be a very busy period for the courts, and therefore it is worth, where possible, looking to try and come to arrangements with tenants if that can speed up the process, because otherwise there are going to be significant delays in the system. That said, if you are in the unfortunate position where you do need to sort of press ahead with possession proceedings, then as I've said in the slides, there are a number of routes that you can sort of lean on in terms of trying to get your case prioritised, and it is important to try and keep on top of that and to notify the court if you think that your case does qualify under one of those priority categories. So yeah, I think it's just a case of trying to move the cases forwards in whatever way is most appropriate for your particular case.
Thank you very much, Sam. Now, I was asking for concluding thoughts, and in fact we've had a further question. This one for David, I think. Can peaceable re-entry be used for other breaches, i.e. other than non-payment of rent, or is it forfeiture which can be used for other breaches, i.e. via section 146, of course, of the Law Property Act 1925? David?
The law provides that peaceable re-entry can be used for other breaches, but as I said, I mean, normally we are tentative about using peaceable re-entry for other breaches. We would occasionally recommend it for rent, but obviously at the moment that's not available. But there are risks with peaceable re-entry, which is of course a type of forfeiture. So to go in and to seek to peaceably upon other breaches, you would need to be on very firm ground before you decide to take any such step. Certainly take advice on it.
Very much, David. Well, I think we're just about there. Thank everyone for attending. I hope found something of interest in there. Certainly there was plenty for me, even as a practitioner in the area. I say we will be circulating these slides. If you do have any questions which you haven't thought of over the coming minutes, hours or days, please do send them in and we'll endeavour to get back to you just as soon as we can. I'd like to thank you very much all for attending. Perhaps just a final thought, if any of you do have any thoughts as to other topics you'd like us to talk about at a future webinar, likewise, please do let us know. I'd just like to say thank you very much for attending. Please keep safe and well, and I wish you and your families a very happy Christmas and New Year. Business again with you soon. Thank you.